Was there anybody who came in while we were gone that would like to speak up here on the agenda? Please let me know, and I'll add your name. Thank you. Ladies and gentlemen, I first want to thank you for your patience. Council has visited on the subject and come up with not yet. So come up with. Who's going to make it? Frank, thanks. We have a motion before council, and Mr. Paul, would you like to move forward with that motion, please? Sorry, I'm sorry. We're coming back from executive session. It is now 7:19. Thank you. Mr. Paul?
A lawyer helped us write this, so you bear with me. I move that we instruct the city attorney to put the First Castle Hills Church, I'll go slowly, and any known prospective purchaser of the church property on notice that the city takes no position at this time on the sale or disposition of any or all of the church's property, but that the church or any other interested party should seek a clarifying order from the court of the consent decree declaring what, if any, future uses may be made of the church property if sold to a third party.
We have a motion on the table that Mr. Paul has made. Do I have a second?
Second.
We have a second by Mr. Daggett. We will go into discussion, and then, of course, there are people signed up for this item. We're going to start to the left this evening with Mr. Trevino. Mr. Trevino, do you have any comments on the item on the table, please?
Yes, sir, Mayor, thank you. I feel that it's important that we came to this decision in order to follow the consent decree, which was placed into effect approximately 10 years ago. It's our understanding that it's still in place, and we were going to be proceeding as such.
Thank you, Mr. Trevino. Mr. Daggett, did you have any comments or questions regarding the item on the table, please?
Not this time.
Thank you, Mr. Daggett. Mr. Squire, did you have any comments, please?
Not
or
this time.
questions?
I'd like to reserve it after public comment.
Thank you, Mr. Squire. Mr. Paul, did you have any comments or questions regarding the item on the table, please?
Not at this time. I agree with Mr. Trevino that we have an order in place, and we see no reason why that order has changed. Nothing has happened, so we would like a clarification of that. Thank you.
Thank you, Mr. Paul. Mr. Gregory, did you have any questions or comments on the item on the table, please?
None at this time, but I would like reserve time after I hear public comment.
Thank you. We'll come back around for another run. Okay, with that said, we have some people signed up for this, I believe. And the first one on the list is Mr. Quentin Baker.
Thank you, Council. You've in receipt of a letter that I sent concerning this matter. I won't repeat all the details in the letter. As you know, I'm strongly opposed to the Basis School proceeding on the property. At the forefront, that whole proposition just flies in the face of the decree that's been entered into by Castle Hills First Baptist Church and the city. It's not a use of the land that was agreed to in the consent. And thus, our strong opposition stating that the church will knowingly enter into an agreement that would improperly use that land. It just flies in the face of that decree. Moreover, we've got significant concerns about the impact of the school with 1,100 students on the property as it sits. Paramount, and that's traffic. I mean, they have no busing to the base of school. So imagine 1,100 kids coming in and out of that property every day. We don't have streets that can handle that traffic load. And thus, we have real concerns about public safety and the impact it's going to have on our streets and our traffic patterns. There is a known drainage issue across that property. There's a drainage ditch there. The layout that they propose puts the school right over that drainage ditch. Okay, so we've got a drainage issue, and we already know well what happens in that neighborhood with the drainage as it is now. So there's some significant infrastructure and safety concerns that we have. And then again, back to the issue of simply defying the decree that the church entered into. Thank you, council.
Thank you, Mr. Baker. The next person on the list is Brother William Dooling.
Thank you. Thank you, Mayor and Council. Brother William Dooling, 201 Gladiola Lane. And yeah, I did sign to speak up because kind of I just wanted to hear. I'm not going to echo what Quentin said because I do think that's the most important issue is there's a federal court order that needs to be followed. But I heard two different things here, and I'm now even more confused because Mr. Trevino said that we have an order in place and we think that's controlling, or words to that effect. But then I heard Mr. Paul say, well, but we're telling the church they should get a clarifying order. Well, why would it need to be clarified if it's controlling? So he said put them on notice. Why would they want to get a clarifying order? If anything needs to be clarified, then we should get the clarification. So it's kind of, as a lot of things in life, it's very gray. Thank you.
Thank you, Mr. Dooling. Next in line is Blakely Fernandez.
Thank you, Mayor and Council. With all due respect to Mr. Paul, the motion, the way it was stated, puts the onus on the church to get a clarifying order, and we have no control over this third party. That doesn't make any sense. We asked the church to get a clarifying order, and their next step is going to be to sell the property as soon as possible. For whatever reason, when the order was written, it was not written to run with the land, which was a mistake. And it wasn't, we don't believe it was filed as part of the deed records. And so if we're going to protect the city's interest in that order, which I think was long, hard fight to negotiate and was very expensive for the taxpayers to negotiate, I think there's $1 million investment in that consent decree, the city needs to get the clarifying order. You can't pass an ordinance of the city that says this third party has to do something. You don't have any governance over them. You can't tell the church what they have to do in terms of getting legal advice. So if we're going to enforce the decree that the citizens invested $1 million in, then we have to take the steps to do that. And that means that this city needs to go back to the court and get clarification on whether the intention of that decree was to run with the land, as it appears to be, but it's not clearly stated, on whether the intention of that decree is that it's contractual in nature, and if you're going to convey the land in order to do a purpose that is not conforming with the decree, that would be a breach of that contract. I mean, these are questions that we have to protect the city's interests. And the motion flips that in a way that's not going to be effective, and it's not going to get the city the answers that they require. So I would respectfully ask that the motion on the table be rescinded, and that a new motion be made that directs the city manager to engage with council to seek a motion from the court as to what those intentions of that decree are moving forward.
Thank you, Ms. Fernandez. Jana Baker. Council, please make any notes you would like to in response to the public's opinion here or their statements, if you'd like to respond. Ms. Baker?
I cannot be nearly as eloquent as Blakely Fernandez is, and I really am struggling to understand what the motion says, and I'd like to ask our city attorney if he could explain it, maybe very simply, so that I can understand what this council is considering.
I will, if I'm instructed, I will.
Mr. Mr. Brennan, would you explain to Ms. Baker the intentions of the motion, please?
The city has received word unofficially, no applications have ever been filed by anybody seeking anything, requesting anything, but the city's been unofficially informed that the Basis Charter School intends to purchase some property from the church. The consent decree is in effect, valid, enforceable, as we understand it. The city's a party to it, and if the school or anybody else buys some of the church property and then comes to the city with an application, the city's going to have to be in a position to respond to the application. If in fact there is a negotiation ongoing and somebody's about to buy the property, we want the church as the seller and the prospective buyer, if there is a known one, to be on notice that until there's a clarifying order from the court saying what use can be made in the future of the property, that until that order is entered, then the consent decree still is in effect and applies. And we don't want the city to be in the position of having set back and let deals be made, money changed hands, and then somebody come along later and say that the city hid behind the log and didn't say, or didn't know, or didn't take a position, didn't protect itself against a possible purchase of the property that violates a consent decree, and that the city is then in a position of having to have a fight
But
about.
that sounds exactly like what y'all are intending to do, is to sit back and do nothing and put the burden back on a third party who has
You
no
know, Jana,
interest.
it's hard for the city to take a position when the city doesn't know what's happening. We don't know who's buying the property. We've received no official notice of anything. All we get is information from the community and what a small bit of information Mike Shands, the city manager, has received. We have no official notice of anything. So how can we, or why should we, jump in a court proceeding and say, hey, we need you to say this, or we need you to say that, when we don't even know what it is?
I think there were other issues, and they weren't just pertaining to a possible sale. They were pertaining to enforcing the decree. And within the decree were issues on drainage and working with the citizens and letting the citizens know what their intended use was going to be and how they were going to use the property. And it's
Well,
my understanding none of
agree
that
with
has
all
happened.
I agree with all of that, but from the city's perspective, what violation is there? You know,
But
we
they
don't
haven't-
know if there's a drainage problem or not. Nobody's come in and said what they're going to do.
They were addressed in the decree
Oh,
and
yeah,
things they had to do that they have not done.
So you want a court order to just say that the decree, consent decree is to be enforced? I mean, or it's valid? We know it's valid.
I think we need to put the burden on the church to tell them we expect them.
That's why we asked, that's why this notice is to the church, to seek the clarifying order to get it straight.
So
We
you're asking
we
the-
can't run out and react to something that we don't know about,
You're asking the church to ask for the clarifying order?
or any other interested party. If it's a citizens group that wants to do it, fine. If the church wants to do it, that's fine. If if Basis Charter School wants to do it, that's fine. If somebody else wants to do it, that's fine. We're going to have to be a necessary party because we're already part of the case.
And if they don't do that?
I don't want to say what the city's going to do if there is no clarifying order and somebody walks in and places an application on the city manager's desk for this or for that, because I don't know what the application is going to say. I don't know what they want, and we're not going to prejudge or try to anticipate the answer to the question that we don't have the question.
I really would prefer that you rescind this motion and reconsider and take the advice of Blakely Fernandez. This is what she does. And perhaps y'all should all seek counsel from Blakely and let her explain that there are other ways to approach this, that the city is actually doing its job to protect the citizens and forcing parties to litigation who agreed to the parameters of it to comply with it. And we're not doing that. we're just going to roll over and say, okay, third party, please go get a clarifying order. It's not going to happen. And I think y'all know that.
Well, nobody suggested that we're rolling over on anything, but, you know, governments, they don't run around and file lawsuits about what might happen in the future that nobody knows what's going to happen.
But
You
we're
can't do
also
that.
complaining about what's in the order, agreed order, that they're not doing. And I think we need to let them know that the citizens would want those agreed provisions attended to. And if the property sells, how do we get it enforced? And that's part of the reason why we're here.
Well, until there's a violation, what is there to enforce? Now, if you're saying there are already violations that have occurred about didn't talk to the neighbors about what their plans are, things like that, maybe that's true, I don't know.
It's a non-compliance of an agreed order.
But what's the non-compliance?
The drainage issues that they've never addressed.
Well, didn't the thing say that they don't have to address them until they build something or do something?
I would argue that chopping down the trees became the beginning of work
When did they chop down some trees?
years ago.
Oh, okay. Well, I don't know, maybe.
I would seriously encourage you to reconsider and not vote for this motion as it is.
Thank you, Ms. Baker.
I think you're failing the citizens if you do.
Thank you, Ms. Baker. Blakely, did you have another comment on that, please?
Thank you. Just two things. One, I mean, citizens groups and neighbors and basis, none of these folks have standing to go back to the court on this issue. There's two parties that have standing, the church and the city, so those are the only two folks that can go back to the court.
Well, the order does say, or any other interested party
Well, I don't know how
can
you,
go in, can interplead in the case.
well, I don't know how they would initiate.
Okay.
Once the land conveys, the basis already has a legal opinion that says once the land conveys that they are not subject to the consent decree. And the fact that the church property is for sale, I think, is enough notice that they intend to breach the contractual violations of that consent decree that we should get the clarification. I don't think it needs to sell before we know that there's an intent to breach the order. It's for sale. So I think that's enough to let us feel right in standing up to make sure that our interests and that federal order are protected.
Thank you, Blakely. Okay, the next one on the list is Mr. Hank Goldstein. Hank is left for the evening. Okay, we're going to come back to our second round of council discussion, and we'll start on the right this time. Mr. Gregory, did you have any comments or questions regarding the item on the table after citizens to be heard?
Mr. Brennan, does the city have a duty or a right to determine to whom the property is sold?
I don't believe so.
Before it's sold?
I don't believe so. What right would we have to do that? Nothing was mentioned about that in the consent decree or the law.
I think it is important with regard to the consent decree. It is in place, period. And it seems to me it is triggered when there is a breach of the compliance of the decree. Now, we're looking at this possible sale, which hasn't been completed, possible sale to a school, as to whether or not it is breaking the consent decree. We don't even know if they're going to sell it to them. I think you have to consider that. The burden should be put on the church, since they're the one that owns the property, as to whether they're in violation of the consent decree. They're the ones who are at risk. If they know that they're in violation, or if they don't care whether they're in violation, they're at grave risk. Mr. Brennan, in your opinion, who has the greater need of a clarification order of the consent decree? The church, the city, or the possible purchaser of any property that is sold?
Well, I think the number one risk is on the purchaser, because a purchaser is going to be spending a substantial amount of money to buy property that they may not be able to use. The next risk is the church, I would think, because if they haven't informed a prospective buyer that there is a consent decree that controls the use of the property, then, in my opinion, they're concealing or hiding important information related to the purchase of the property. Third, I don't think the city's at risk at all at this point, at this moment in time, because the city has received no application from anybody to do anything. And as far as the city's concerned, the consent decree's in effect, it's in full force in effect, it's enforceable, and unless a violation of it happens, the city's not at risk at this moment.
The gun is loaded, the trigger's cocked, but nothing has been shot.
That's right. A government can't go around and solve problems that aren't known problems. You know, you just can't do that.
What, in your mind, Mr. Brennan, or Mr. Shands, either one, is the difference between the motion that has been proposed and the resolution which was proposed?
Well, there was a possible resolution that, I don't know, this said pretty much the same thing as what this motion says. And the motion says is that the city basically wants notice given to the interested parties that are known interested parties that the consent decree does exist, and if they want to use the property for any purpose other than what the consent decree says, they better get a clarifying order in advance. And if somebody seeks a clarifying order, the city's going to be a party to that and has the right at that point in time to assert a position if it wants to deny the clarifying order. But we're not at that position at this point in time.
Mr. Shands, do you see any no, I'm not going to ask that.
I don't see much in this at all. I left my law degree at home today, but I will certainly answer any other questions you might have.
Thank you, Mr. Gregory. Mr. Paul, did you have any comments or questions after the, go ahead, sir.
Not much. To me, the explanation that Mr. Brennan gave is the one that I rely on. There's been no breach of anything at this point in time, and we're telling them, don't breach it. They're reminding them, whatever the case may be. So anyway, that's all.
Thank you, Mr. Paul. Mr. Squire, did you have any comments, please?
Yeah, first of all, I appreciate the comments from everybody here today, or, you know, that spoke anyways. For one, certainly appreciate it. Gives me some more things to think about. A quick question, Mr. Brennan, and it was brought up by Ms. Baker that allegedly that the church has already violated the court order. If they have, what is our recourse at this point in time?
Well, the recourse for any violation of a pending court order is to seek either enforcement of the court order to rectify the violation or to seek penalties for violation.
I guess I want to be curious to find out, and if Ms. Baker would share the violations or what we know of any violations that have happened.
I wasn't aware of any known violations of the pending court order. That doesn't mean they might not have happened. I've never been informed of.
The court order does have some relatively soft language in it, if lack of better terms, that they can get away with quite a bit for a while, but based on their finances, it looks like, in the decree. So I was just kind of curious. I'd like to know what they violated, number one, and number two, I'd like to know what we can do about it.
Well,
if indeed everything was done.
I wouldn't want to be accused of violating a federal court order if it was me. And I hate to say that they're soft because they can be very tough.
Oh, I see your point. If indeed the sale does go through and Basis does purchase the land, this is going to have to come, will it have to come back before council? Is there, I understand there's some state, there's some exclusions that the state provides for them in regards to zoning, but will it have to come back in front of us?
There are a number of things that are going to happen that will come back before you, including building permits, architectural design, drainage plans that need approval.
At that point in time, if the issue of the court order has not been settled, if indeed this moves forward and a judge hasn't ruled on that, is that something that we can, at that point, want to investigate before we approve anything?
Certainly.
Okay. I mean, I know at council we stopped other non-desirable projects in our city before. Council's done, I think, a good job of that in the past. There's been wonderful public input, and I think that process will continue in this case too. So I do appreciate that, but no more questions. Thank you.
Thank you, Mr. Squire. Mr. Daggett, did you have any comments on the motion moving forward?
Just a couple. I kind of want to second what John Squire said and what was presented earlier. We do have governance because we don't know what will be presented later, but we do not want to also, as a city, be in violation of the consent decree, and by us going forward and violating it, we're not going to put ourselves in that position also. So we want the consent decree clarified on this matter and any further use of that property whatsoever. Basis may say they have an opinion. We don't care what their opinion may be. We want the court that has jurisdiction over this consent decree to be the final authority on it, because they're the only ones that are going to say either way on this, not us or any other attorney. That's all I have at this point.
Thank you, Mr. Daggett. Mr. Trevino, did you have any final questions, please?
Yes, sir, Mayor. Just wanted to thank everybody for coming and for sticking it out with us. It's important that we realize that we plan on making sure that the consent decree stands, and we are going to proceed as such. If Mr. Brennan, if somebody were to come and try to get some sort of application based on the existing status of the consent decree, it probably would have to be reviewed, correct?
We have to have notice of everything that's being requested, and at that point in time, we'll be in a position to decide what position to take.
Thank you. And that's just to point out that we're under the impression that there are safeguards in place to protect that area of the city and ensure that there's not development there as per the consent decree.
Mr. Mayor, may I ask the city attorney another question?
Of course. Thank you, Mr. Trevino. Mr. Gregory?
Mr. Brennan, in the proposed resolution, it says to support a thorough review of the legality of the proposal of Basis Charter Schools to operate a charter school on property, blah, 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 blah. Well, there's no proposal.
There's no what?
But there's no proposal as yet.
Oh, right.
But the second there is a concrete proposal, and that can only come about when the land is transferred. Is the city in a stronger point of view while the land is still in the hands of the city, or if it goes into the hands of the charter school?
Did you mean in the hands of the church?
Hands of the church versus the charter school, which may do something on this property. Is our hand stronger if the property is still in the hands of the church, or if it transfers to the charter school, is our hand weakened?
Well, I don't know. It's hard to say about that. I think a court is going to be, a court will thoroughly consider everybody's position if this thing is reopened, and that's why I suggested a clarifying order. If it's reopened, the court is going to consider the public's interest, just like they did in the existing case. They're going to consider the church's interest, I guess, to sell property. They certainly have a right to sell their property if they want to. And I think a buyer, they're going to consider the buyer's potential use of the property too. And I think it will be an adequate or fair forum to resolve those issues, like it was the first time.
I'm not sure that answered my question.
Okay.
Right now, the motions as it stands basically is putting the church on notice.
And prospective buyers.
And that could be anybody or
That's right.
nobody.
That's right.
But right now, if there is a disagreement, it's only between the owner of the property and the city, if there is a disagreement. But are you bringing in, if the property changes hands, you're absolutely bringing in a third party. So you're now going to be looking at two people that the city will be fighting versus one. And does that make you said it's hard to figure out, but I think it's the crux of the question. Does it make the city, does it put the position of the city in a more vulnerable position when we're only dealing with the owner of the property versus the past owner of the property and the future owner of the property if it changes hands?
Well, all I can give you is what I know, and what I know is the church is not selling all of its property. It's proposing to sell part of its property. And I don't see that our position is weakened if they've consummated or closed the sale of a part of the property to somebody else, because the church has still got to live with the rules. The new buyer's got to live with whatever order the court makes for it. And you know, I don't know how you can put it on a relative scale that we're stronger or we're weaker if we wait till the sale happens or not happens.
Well, Tim and I, the mayor and I, are the only people on the council who remember when. Unfortunately, we've been on there long. He's taken his hair off and shaved it. I've kept mine, but mine's grown gray and his is gone. But the arguments made back then, I can hear the same arguments future. Well, we can't do anything because it costs too much. And the argument shifts from the problem of the argument versus the cost of the argument. And to me, it seems offhand that the cost of the argument is amplified when you're dealing with the church, the previous owner, and the new owner, because one or the other is going to bring in a lot of money against you. I think that's important. I really do, because we're not River Oaks. We do not have unlimited supply of money, but we have neighborhoods that have to be protected. The bottom line of this motion is that one way or another, it's going to go to the court for clarification, correct?
That's what we're asking for at this point in time. But we don't have any other action. We can't file a contempt motion because they violated it, because they hadn't violated it that we know of. We can't ask for sanctions or penalties because there hadn't been a violation that we know of. The use will become the violation if there is a violation.
So it'd probably be better for the city's sake to put the churches who owns the property now on notice that we're going to we expect you to find out what you can do with your own property.
Yeah. The fact that we're asking them or putting them on notice that they need to do that
versus
is a position.
If they go merrily along and say, we don't have to do this, we're going to sell it anyway.
Yeah.
And they bring in a third party. At least, all right, okay.
I got a question, a springboard on his. Why would they think that? Why would they think that if we're passing a motion like this, why would they think that we're taking any kind of soft approach towards this?
Well, I mean, I don't know what more we can say. You know, we could use stronger language like we're gonna sue you if you do something or
Hang
other.
on, Quentin, hang
But
on.
what we're saying is we're stating reality, and that is, if you're gonna sell your property to a third-party user, then you better get a clarifying order of the consent decree that's gonna permit or authorize what they propose to do with it.
Okay, on that, I want to ask another question. I suppose it's my turn. Mike, if Basis walked in today or after the sale of the land and asked to be issued a permit to start building, what would the city of Castle Hills do?
Well, I can't say for sure because I don't know what the permit application is gonna be. But our position would have to be that if it complies with the consent decree, maybe. If it doesn't comply with the consent decree, then probably not.
The court order, and I just want to make sure I understand for council, the court order has to be breached before we can move forward with anything that they've violated? Did I hear that?
No, I wouldn't say that. I mean, any party, the church, the city, or any other interested party can go down there and file a motion to clarify, a motion to modify, a motion to terminate. You can do, anybody can go down there and ask for anything they want.
For what?
But if we want to punish somebody for not complying with it, then that's something that we would need to do, and we would ask for damages or penalties or contempt or some other relief.
The last question I have, and it's just for general knowledge, if we did go down there and go ahead and move forward with this, where would that money come from? Would it come from the general fund, or where would it come from?
It'd come out of the money that this city was going to use for streets and drainage repairs.
Okay.
General fund.
Okay, is there any way that TML would be backing us on this, do you feel, as far as helping the city pay for it if this went into $100,000, $200,000, $300,000 lawsuit?
Probably not, because they only are required to represent us when somebody's seeking monetary damages against us, and they generally do not represent us in land use cases, and this is pretty much a land use case.
So basically, at this point, if we move forward with anything stronger than this particular motion, would Basis be able to come back and say that we tainted their land sale?
Well, they could say that, but that wouldn't be a valid legal position for them to take, I don't think.
Okay. Okay,
It
thank you.
just
That's all I
opens up the
needed to know.
treasury.
Let's do council first, and then I'd see there's some hands out there. Douglas?
Mr. Brennan, if we went to the court and we're asking a clarification, would the court come back to say it's moot? It doesn't, you have no problem here, you can't define what the problem is because you think we think this is gonna happen, but we don't know. Would the court more likely than not at that time say it's a moot question?
Courts are not generally in favor of answering hypothetical questions. There needs to be an act or an event that has occurred that gives them jurisdiction to take some action. I'm not saying they can't ask or answer a hypothetical question, but normally they don't do that.
So, on the one hand, you have the city with a binding court order, and it's fair for everybody to see. And it's the risk of the person on the other side to proceed knowing there's a binding court order. It would be to their temporary advantage to find out exactly where they're wandering into. Is that correct or
If it was
incorrect?
my client, I would want to know.
Thank you.
Thank you, Mr. Gregory. Quentin, I think you raised your hand, or Brother Dooling, you did first, but I recognize the fact that Quentin raised his hand again, and also Brother Dooling so far.
Just ever so briefly, while we were sitting here, I went on Basis website, and they list Basis San Antonio Charter School, in parentheses, future, with a picture of Winston Lane, saying, new charter school at 117 South Winston Lane, San Antonio, Texas. And they also listed in their enrollment, when you go to their website, Now, it doesn't specifically say they're taking enrollment for this school, but it's listed among the 3 campuses, Floyd Curl, Ramsey, and South Winston Lane. So somebody's planning on building a school there. That-
Are they
so-
plan on building a school
The
or
only
using
thing I
existing
would add
buildings?
to that is the other time we had this kind of an issue was with the deaf seminarians. And it was an issue of them buying the property and then saying, oops, we didn't know about your ordinance involving unrelated cohabitants. Well, I just think it needs to be made crystal clear. And one way of doing it is getting it in the paper too, or online or something of, you know, this is not just a normal real estate transaction and you best tread carefully. That's my feeling.
Okay. Quentin?
I appreciate the clarifications from Mike. A couple of points. We've got a motion on the floor that deals with giving notice. I agree with giving notice. I think that's a good concept. We can separate out the issue of going to a court for clarification as a separate action, so not to cloud the issue. On the motion on the floor on giving notice, I would like to see it be a much stronger worded notice. As Brother Diddley just pointed out, the school in essence has put out public notice of the intent to build a school. So while we, the city, don't have any official applications, it's certainly out there in the public. There's a graphic they have put out depicting a school built on that lot, okay? So we, the city, can see their intent. It's in the public, right? And we could cite that in the letter saying, we see public notification that you tend to build a school on this property. That's out there, right? Now, I'd like to see the language strengthened in the notice letter. I'd actually suggest you take out the suggestion that they go get court consent. Why should we suggest that? I would rather see us as a city go do that so we are in the strongest possible position. So my suggestion is omit the suggestion from our notice letter of them going to the court, okay? I would like to see you add in the notice letter a very firm statement that the city would consider building a school on that property to be a violation of the decree. A very simple statement. We would consider that to be a violation of the decree. You're on notice. I think that'd be a much stronger letter, a much stronger position. Okay, thank you.
Mr. Brennan, on that question, would that put the city in harm's way?
I don't know, but I don't want to send a notice that prejudges that they're in violation of the decree until the city knows precisely what's being requested. I know there's a picture and there's plans and advertisements and all that kind of stuff. That's not binding on anybody. It's never been submitted to the city in an official way. And for us to assert a clear-cut violation, I just don't see how we can do that validly or legitimately.
Okay, good point. How about taking the reverse position, which is to say, we remind the parties that the decree specifically states this usage of the property, and we can cite the language in the decree on the permitted usage.
I might do that. I might do that.
That way, we can state exactly what's in the decree. We're not accusing them of violation,
Yeah.
but we tell them what's acceptable.
Well, yeah, I agree. I agree. That's better than presuming that there's a violation already in place.
Mr. Paul and Mr. Douglas, we're going to take a 5-minute break. Would you visit with Mr. Brennan? And you guys, since Mr. Paul, we do have a motion on the table. We do have a second, whether or not we're going to move forward with an amendment on the thing on the table. Thank you. We're going to take 5 minutes, please.
if they, like Squire saying, or Brennan saying, "Well, what did the school do? You know, why are we voting? The school stepped out of the consent decree when they started bulldozing the 6 acres.
Yeah.
And didn't complete.
Right, right, that's what Janice said. She said that they started the site work, and then that started, so the drainage work should have followed the site
I
work.
was in the middle of that, so what they said at that particular time, and all of us, objected to it, they said, no, we're not starting the multi-use facility. We're clearing the land so we can have a practice field for our,
And then they have used it that way all this time.
and they've used it all that time. And there's documents that, to that effect from the church and exchanging, is this the start of the multi-use facility? And they said no, because the multi-use facility was not a football field for one thing. It was a soccer field and a softball.
Yeah.
But Steve, just by them saying no, that we're not doing it, what Prince did was lay out in that 42-page document that the city could take action to say, hold it, church, you started.
The site work is usually enough to say you've started.
Yes, you
Because
started, so then what I was
that's
trying to
usually-
get was the drainage, to get the drainage installed.
The site work is usually enough to say you've started because you get permits for doing site work, but in this case, they didn't get the permits for doing site work,
No,
which is
they got a tree trimming permit.
yeah, yeah. But I think it's a gray enough area that you could certainly make that argument.
Well,
No, they got a tree trimming permit, but then they bulldozed it down, but then they didn't get the required state permit. So,
No, but I will say this, that it's like taking a survey. Surveyors call your house, and the way they frame the question predicts your response, right? You don't want the other side asking the court the question. We want to ask the question. We want to ask the question that's framed with all of our arguments so that the court sides with us. When they ask the question, it's going to be phrased so that the court leans on them. I mean,
That's a good point. That's something that hasn't been brought up.
my friend's so annoying. He just doesn't want to do the work.
And I'm not concerned about the work. I'm more concerned about making sure that the plans are open.
If anybody can get the clarifying order, right? So there's no, anybody except someone who doesn't have any standing. Anyway, the church isn't going to get it, and Basis isn't going to get it. Basis does not require a zoning permit. They're going to buy the land. They've got their attorneys who've said that they are not subject to the consent decree, and they're going to sue for permits. And at that point, they're probably going to win because they're going to sue in district court, and they're going to say that the federal decree is between two parties, and one of those parties doesn't own this land anymore. And the district courts will always side with the person who's asking for forgiveness instead of permission. Anyway, we're just decimating our position.
So even if we provide notice that this was an issue before they contracted.
The notice helps, but it's
And
not.
that's kind of our intent to
But
show that, look, there's
But
an
we
issue.
should want to ask the court, not have them ask the court. We're giving away all of our power when we ask them. They either will ask the court in the way they hedge it, or they'll just ignore us. They're not, you can't make them.
Has anybody on the council read what the judge did 10 years ago, told us what we could do?
They've all been given
Have y'all
copies.
read that bit? So what was the answer after 10 years?
Look, it lasts for 20 years.
It's a 20-year degree.
It was 20? I thought it was 10.
No, we're only halfway through it.
Oh, we're halfway through. It was 20 years?
Yeah, 2027. So signed in 2007 is 20 years.
I went to that court.
We wanted to make it forever.
We don't know how
We settled on 20 years.
spiral out. It's just going to be one year then, or we go to the court and then it's going to be back to court.
Well, you asked Basis to go to the court. Who do you think got the legislation put in place that you can put a charter school anywhere you want in a town of 20,000 people or less? These people have resources. I mean, the city thought they were going up against a beast with the
because the
But if we
drainage
don't-
issues,
But if they sell the land, it's too late to make it a condition of purchase.
the drainage issues do not start being corrected until the church starts the sports complex.
And the question is whether site work began the construction, so when they tore the trees down, was
Know
that
this
enough
too,
to
that,
start it?
that the drainage issue is not on the land that they're selling, it's on the other side of the street. So that, part of that is that, I think a case could be made, even if you sell the land, the drainage issue has to be solved first.
Right.
Because that's still the church's property.
Right, and then just compound the issue with any kind of development.
Yeah. So when they bulldozed down the trees, it was my opinion, that started.
Site work.
Well, sure, I mean, as far as.
Well, because the church did an end run. They sent a letter to the city and said, no, that's not our intentions, blah, blah, whatever. JR, I paid for a memorandum of opinion by an attorney that filed an amicus brief during the federal court. He cited case law that would be sufficient for the city as what's the two parties called, Blakely, standing. The city's got standing that they could say, hold it, church, you did start, you need to finish it. And what I was trying to do is to get that drainage to start, the drainage correction to start. So I had this thing prepared, and then what I was told by the mayor at that time, Wayne, we want to heal them by now. Can we just stop that? The church has promised me they're not going to do anything else. Let's just wait and see.
Now, and I understand you're right, and I'm completely on point with that. Is there a statute of limitations as far as they should have done it? They cut down the trees 10 years ago and haven't done anything since then?
They had 2 years to finish the whole project, phase 1 of the project out,
Once they start.
Right, and I understand, but my point is, if we come back and say, hey, you never did any drainage control, it's been 10 years, but you have cut down those trees, do we have any grounds there that something's gonna have to go back?
I mean,
I think the
it's
city
gray
agreed that
enough.
it was not the start of the project. That's probably the problem.
They didn't want to be involved.
Correct.
Well,
Get out of it.
They wanted
But
to
the-
heal.
clouded,
The bigger
there's a
issue
cloudy
is-
issue at that point because the church didn't have the money to do the multi-use facility. They got the land sitting over there. They had the football team and they wanted to use it for a practice field. I mean, that was what they said and that's what they've done.
But because the decree doesn't expressly run with the land, we don't have any
Well,
way
football
to
team
attach those drainage solutions to the new purchaser.
Yeah,
It needs to be,
yeah.
it needs to all be tied together. The only way to do that is for a court to say, yes, we're not gonna inhibit your right to sell the land, but the purchaser has to, conform to the uses for the remainder of the decree, and they're subject to the same drainage requirements as an assignee of the decree. Otherwise, there's nothing, and once they sell the land, we're not gonna fight it.
I think the
And
thing
it's
is,
gonna be confusing on how you fight it. Basis isn't a party to this.
Right here in the middle of everything.
Right, I mean, I understand basis in the party, but the land is, and within that, as far as the consent decree, that's still standing and all that.
I would argue if I were representing basis, that the consent decree doesn't run with the land.
But if that's the case, then the church could have sold it 6 months after that and said, okay, this is,
They could have, I mean, if that's the case, but they could have, if they did it as a shell entity, that would have been different, right? Because you could have, that would have been fraud on the court, if they sold it to themselves.
I say that loosely, I mean,
I know,
whatever which
but,
way.
the point would be to attach the rights and responsibilities of that decree to the purchaser for the remainder of the term.
Right, well, and from what I understand, the consent decree has some holes in there that should have been
Ladies and gentlemen, if we can find our seats, we're at the 5-minute mark.
So they go hook it up yesterday? I'll go home at lunch, okay? 12:40, clock in the house. You're gonna have service, right? Everything works. Awesome. The microwave spill's pouring out of it. Turn it off.
Okay. It's now 8:16, and we're going to reconvene after our break. Oh, okay. Thank you, Mr. Paul. Okay. There's two ways we can do this, I understand, Mr. Brennan. Are we going to scrap the original motion in second, or are we going to do an amendment to the motion?
I think just an amendment to the motion.
Thank you. Okay, with that said, we have a motion by Mr. Paul. We have a second by Mr. Daggett of the motion on the table. Do I have an amendment to that original motion, please?
I do. Shall I read it? Amend the notice to include, in the notice, a simple summary of the uses authorized in this consent decree. It'll be fleshed out, of course. Amend the notice to include a simple summary of the uses authorized in the consent decree.
Thank you, Douglas. We have a motion, we have a motion for an amendment on the table. Do I have a second? I'll second. We have a second by Mr. Squire. All in favor? It's unanimous. Thank you, council. Kim, did you get all that, or are we gonna, okay, good. Okay, we have an original motion on the table. Mr. Paul, would you like to read the original motion, please? And then we're gonna take a vote after that.
I move that we instruct the city attorney to put the Castle Hills Church and any known prospective purchaser of the church property, of church property, not the, of church property, on notice that the city takes no position at this time on the sale or disposition of any or all of the church's property, but that the church or any other interested party should seek a clarifying order from the court of the consent decree declaring what, if any, further uses may be made of this church property if sold to a third party. And the amendment says that this will also include a simple summary of uses authorized in the consent decree.
Okay, we've reread the motion. We've also reread the amendment that was tied to the motion. With that said, we will take a roll call vote on this, please. Mr. Trevino, how do you vote?
I vote to accept the motion with the amendment.
Mr. Daggett?
For?
Mr. Squire? Aye. Mr. Paul? Mr. Gregory?
Aye.
It passed unanimously. Thank you, council, for that. Everyone, thank you for being here tonight and your input. And we will move on to the next item on the agenda. The next item on the agenda is 2B. The City of Castle Hills will convene in closed session as authorized by Section 551.0741 of the Texas Government Code to discuss and take possible action regarding the engagement of a city manager. I would want, of course, everyone, please stay, but this could take up to an hour to 2 hours. So I wanted to tell you in advance that We have a very, very lengthy process that we're going to do, and we invite you and encourage you to stay and see how the outcome is. I promise that when we come out of executive session that we will act very quickly. Thank you.
It'll be a long while. Go ahead and have supper. I'm not going to go home for hours. Go ahead, bye.
As quickly as possible.